This segment I want to talk to you about the presidency and the Constitution. It's no surprise, and of course, that it's placed such heavy emphasis on our being a constitutional democracy and on the rule of law that we want to begin by looking at the rules that are actually embedded in the Constitution. The first issue to take up is what are the qualifications to be President of the United States? They're very simple. The words of the Constitution: you must be a natural-born citizen of the United States, a resident of the United States for 14 years, and 35 years of age. Of those requirements, only really the last one, 35 years of age, has turned out to be very operational. There have been a few individuals younger than 35 who sought the office of presidency or were considered for the office of presidency who were excluded because they were too young. One candidate who was never elected was William Jennings Bryan. He ran when he was 36. The other requirement, that you be a natural-born citizen of the United States, has not eliminated any people, including some people who obviously were born outside of the United States. George Romney, the father of Mitt Romney, wanted to run. He had been born in Arizona when Arizona was a territory. So technically he was not a natural-born citizen of the United States. John McCain was born in a hospital in Panama, not inside the Panama Canal Zone, but because he was the child of military officers stationed abroad, he was considered a natural-born citizen of the United States. And then, of course, there was this entirely spurious and silly argument that Obama, who was born in Hawaii while it was a state of the United States, some speculation that he was not. So we have not had anyone in recent memory who has been disqualified because he was not a natural-born citizen of the United States. Though there are a few prominent people, such as Henry Kissinger, Secretary of State, and another Secretary of State, Madeleine Albright, who were not born in the United States, and I suppose for some might have been considered presidential candidates. Currently, Arnold Schwarzenegger would be a possibility. But if you look at it, there are no other qualifications. These are not real qualifications. They're just conditions that are imposed on the office. There's no requirement for any education. You don't have to graduate from college, and you don't have to go to school at all. And three of the presidents, Washington and Lincoln, prominent, successful presidents, had no education, no formal education beyond a few months at all. Andrew Johnson had nothing, and yet was president. So, no educational requirements. No requirements that you have military service. We've had people who didn't have military service, some of whom were questioned in the campaign about their lack of military service, but certainly they were not disqualified from holding the office. So you don't, and you have no requirement of any prior public service. We've had a number of candidates, successful candidates for presidency, who had no other political office prior to being elected president. Zachary Taylor immediately comes to mind. So it is a curious thing that there are no qualifications. The second thing that's curious about the presidency is if you look at the powers of the presidency and compare them to the powers granted to the Congress, the president has no powers at all. Congress has virtually all of the significant powers granted to the national government in Article 1, Section 8. The president has just a small smattering of powers. The power to require the opinions of the officers of the executive branch in writing. Well, he appointed them. He surely can get them to write him something if he wants them to write it. He has the power to grant pardons, but only pardons for those who have been convicted or accused of federal offenses. All of the state laws and state convictions cannot be touched by a president. And the president has the power to negotiate treaties, but of course subject only to the ratification by the Senate. He has the power of a veto, but the veto power, which looks formidable, I suppose, from the standpoint of senators and congressmen, is really a difficult tool to use. It's difficult because if you exercise the veto, you're throwing out the good parts of the legislation as well as the bad. The president, unlike 43 of the American governors, has no item veto. Not a very great power. And again, The power of the veto is a power that can be overturned by the Congress. It takes a 2/3 vote in both houses, but still, that is something that can and has happened in American history. The president gets to appoint the executive officers of the government, that is the secretaries of state and so on, but that's subject to confirmation by the Senate. So, and he can appoint federal judges, but again subject to confirmation. There is a list of powers, but they are not exhaustive. And indeed, when we look at the presidency and correctly conclude that presidents in the 21st century are vastly more powerful than the presidents who served, say, in the 18th and 19th centuries, that's a correct conclusion. But the conclusion is not that they were granted by the Constitution. Rather, it is that presidents gained what additional powers they had from enactments of the Congress. I'll take that up in the next segment when I talk about active political power for the president. Finally, there is one more. The president cannot declare war, and the president does not have the power of the purse. But should war break out, the president becomes the commander-in-chief of the armed forces and of the militia of the several states if called into the actual service of the government. In wartime, a president becomes the most powerful military leader in the country. And given that a military is so important during wartime, that is a very considerable power. But it is not, in the usual sense of the word, a political power to be exercised on a regular basis. Given that the Constitution has so few official powers, there also was no significant limit. The conception in the framers' mind was that since the president was not particularly powerful, he was a kind of clerk, except in wartime. There was no need to place any great limit on the president. But they were convinced that separation of powers and checks and balances were important, so some kind of check had to be imposed. The check that they came up with, initially, was the power of impeachment. Now, there's always a power in the American system as a result of recurring elections. So one power that they clearly thought existed in the hands of the people was the power not to re-elect someone running for president a second time. But during the term of office, during the time when the president is actually exercising power, the only thing that the framers were willing to do to limit a president's power was to use impeachment. Of course, granted that they hadn't given him very many powers, it didn't seem necessary that he had very many limits. What about this power of impeachment? What does it amount to? Well, it's a curious kind of thing. Impeachment was something we inherited from the British. The British used impeachment as a way of avoiding the kinds of revolutions that would require them to throw the king out, perhaps even execute him. They felt they couldn't remove the king, who had a lifetime term, and instead, their only way of getting at the king, who was abusing his power, was to get rid of the officers or officials of the government that the king had hired. And impeachment was used to get rid of those officers of the government. It required a vote in the legislature, in that case the British House of Commons and the House of Lords, but that was the only way they had to try to limit the king. It's an odd kind of thing to use. We used it because we couldn't think of anything else. And we started to use it and have continued to use it when the British gave it up. It was so awkward for the British that they didn't use impeachment after 1796. They instead depended on their power the power of the House of Commons to name the Prime Minister. So impeachment is an odd duck. And if we look at the terms of impeachment, it's an even odder duck. Impeachment indeed does apply to the president and to the civil officers of the government, but not military officers, and to federal judges. All can be impeached. In order to be impeached, there has to be a majority vote in the House of Representatives. That is the act of impeachment. Any of these officials, subject to a majority vote in the House of Representatives, have been impeached. So, Andrew Johnson and Bill Clinton were both impeached. But neither was convicted, and neither was removed from office. So in that sense, the word impeachment has to be looked at as if it were like the word indictment in the legal system. It's a formal questioning, a formal challenging, a formal indictment of an official's behavior, but it's not a conviction, and it's not a removal from office. That has to come later as a result of a trial in the Senate, where a 2/3 vote is required to convict. We have had very few impeachments, and we had no impeachment and convictions of any presidents. We have had just a handful of impeachments and convictions of federal judges, and part of the reason is that all of these officials have a partisan affiliation. And when you get to the Senate, it turns out to be very difficult to get all of the members of 2/3 of the members of the Senate to convict, because the partisan divide in the Senate is more evenly split. Today it's almost exactly split between Democrats and Republicans, with the Democrats having just a couple more seats than Republicans. The problem is that people in the minority party have the power to block by refusing to vote for a conviction, and so it has been. In both cases of the impeachment of presidents, there was a failure of the Senate to come up with a 2/3 majority, and that's very likely. The number of times that one party has had a 2/3 vote in my lifetime has been only twice. Lyndon Johnson had a 2/3 majority briefly for 2 years in 1967 and 1968. I'm sorry, in 1965 and 1966. And Barack Obama had a 2/3 majority for just a few months in his first year in office. So all the rest of the time, neither party has had a 2/3 majority. So trying to get a conviction from party members of another member of their party is very difficult. It takes overwhelming evidence of wrongdoing. We've never come up with it against a president, and we've hardly ever come up with it against federal judges. That's not to say that impeachment is entirely useless. You can't say how many times a president has refrained from engaging in illegal activity because of the threat of impeachment. So you can never be quite sure that impeachment wasn't doing its job just by threatening to impeach and remove someone for wrongdoing. And arguably, the power of impeachment played a large role in the resignation of Richard Nixon. Richard Nixon was not impeached, and he was not convicted, but he was removed from office by the process of impeachment. He resigned in August of 1974 as the result of litigation that had reached the point where it was obvious that he had committed a major crime. He was then informed that the House of Representatives was going to impeach him in a matter of a couple of days, and he was further told that his political support in the Senate, even among members of his own party, had fallen to less than 10. Knowing that he would then be impeached and that he would then be convicted, he resigned to protect his pension and to give him sort of talking points about how he wasn't actually impeached and convicted. He just quit on his own, trying to save the country and all that sort of stuff that people say when they've been caught with their hand in the cookie jar and are trying to weasel out. So, impeachment, not a very useful kind of thing. It does, and this is worth noting, impeachment is only a removal from office. It is not a conviction. Someone who is removed from office is then subject to further indictment, trial, and conviction in ordinary courts. So impeachment is in a sense removing a legal immunity from the office of president, or from someone in the office of president, so that he can be tried like an ordinary citizen. Finally, impeachment is complicated because the words for impeachment, or the crimes for which impeachment is appropriate, are really arcane. Two of them, treason and bribery, are almost impossible to get a conviction. Treason requires the witnesses of the testimony of two witnesses in open court to an act that occurred in wartime. Almost impossible to get. And secondly, bribery is the kind of crime that can only give you a conviction if you can get a person to say they're guilty. You have, in the case of bribery, someone who has taken a bribe, he's not going to admit he took the bribe, and someone who gave the bribe, he's not going to admit he gave the bribe. It's a very hard conviction to get. The only real penalty, the only real criteria for impeachment is high crimes and misdemeanors. That's a phrase that is so vague that it is argued over virtually every time we have a proposed impeachment. It's a little easier for federal judges because they're required to serve for good behavior, and so there's a broader sense to the law in those cases. But all in all, impeachment has been an awkward sort of tool to use and would probably not be adopted if we had a chance to do it